Imagine a couple just 4 months into their marriage realizing that they are incompatible and no longer wish to stay together. The legal system, however, mandates that they wait for a specific period before they can officially end their relationship. But what if that wait only deepens their agony, preventing them from moving on with their lives? This is precisely what happened in a recent landmark case decided by the Karnataka High Court in 2023. The court's ruling made waves across India as it challenged the traditional approach to mutual consent divorce. Today, we are diving into the details of this groundbreaking judgment and explore its implications for couples seeking a divorce by mutual consent. Here are some points that we would discuss. First, waiver of cooling off period. The Karnataka High Court ruled that the statutory cooling off period for mutual consent divorce is directory and not mandatory. 2. Case law's references. The judgment aligns with precedents like Amardeep Singh versus Harveen Kaur and Amit Kumar versus Suman Beniwal, where flexibility was provided to the couple. 3. Context of the case. A couple sought a divorce just 4 months into their marriage, realizing that they were incompatible. 4. Judicial commentary. The court emphasized that forcing a waiting period in such cases would only add to the couple's suffering. The case that triggered this shift involved a couple who had been only married for 4 months but found themselves unable to reconcile their differences. They approached the Karnataka High Court requesting for a waiver of the statutory cooling off period mandated under the Special Marriage Act. The court, led by Justice G. Narendra and Vijay Kumar A. Patel, ruled in their favor, allowing them to proceed with the divorce without any further delay. In his judgment, the Karnataka High Court referenced the Supreme Court's ruling in Amardeep Singh versus Harveen Kaur. In this case, the Apex Court held that the 6-month cooling off period under Section 13B subclause 2 of the Hindu Marriage Act is not mandatory. The court has the direction to waive it if it sees no point in waiting. The ruling set a precedent for cases where the couple mutually agrees to that reconciliation is impossible. Similarly, in Amit Kumar versus Suman Beniwal, the Supreme Court reiterated that the waiting period mentioned in the statute is directory in nature. The discretion lies with the court to assess whether reconciliation between the party is likely or not. In the Karnataka High Court case, the couple had tried their best to resolve their differences but ultimately decided to part ways without making any allegations against each other. The court observed that any further waiting period would only prolong their suffering. Therefore, it was deemed appropriate to exercise judicial discretion and waive of the cooling off period. This ruling is significant because it recognizes the emotional and psychological impact of forcing couples to wait unnecessarily. By allowing flexibility in this process, the court acknowledged that in certain situations, the legal process should not become a barrier to a personal well-being. If you find yourself in a similar situation where you and your spouse have mutually decided to end your marriage, but the cooling off period seems unnecessary, here are the steps you can take. First, file a joint petition. Begin by filing a joint petition for divorce under Section 13B of the Hindu Marriage Act or the relevant provisions of the Special Marriage Act, depending on your marriage. 2. Request for a waiver. If both the parties agree that reconciliation is impossible, you can request the court to waive the cooling off period. Be prepared to present evidence that supports your request, such as counseling records and affidavits. 3. Legal representation. It is essential to have a lawyer who understands the nuances of divorce law and can guide you through the process. 4. Judicial discretion. Remember that final decision rests with the court. While you can request a waiver, the court will assess whether it's appropriate based on the facts of your case. In recent months, several high courts across India have echoed the sentiments of the Karnataka High Court. For instance, the Delhi High Court ruled that mutual consent divorce should not be delayed unnecessarily if both the parties are in agreement. The courts are becoming more sensitive to the emotional strain of prolonged divorce proceedings and are increasingly willing to waive the cooling off period when it serves no purpose. This trend highlights a broader shift towards a more compassionate approach to divorce law in India. To recap, here are the key takeaways. First, the Karnataka High Court's 2023 ruling for the waiver of cooling off period in mutual consent divorce cases, recognizing that this waiting period is directory and not mandatory. 2. The judgment aligns with previous rulings by the Supreme Court such as Amardeep Singh versus Harvind Kaur. 3. The court emphasized that forcing couples to wait unnecessarily can prolong their suffering and judicial discretion should be exercised to prevent this. 4. If you find yourself in a similar situation, you can file a waiver of cooling off period and seek legal advice to guide you through the process. 5. Recent trends indicate that courts across India are increasingly adopting a more flexible approach to mutual consent divorce. Remember, if you're going through a divorce, it's essential to have the right legal support. Subscribe to our channel for more updates on important legal judgments and don't forget to like, share this video if you found it useful. Take care and bye-bye.